Welcome back, everybody, to our studies of the law of contracts. In this lesson, we're going to continue to talk about the idea of the offer and the acceptance of a contract, and we're going to focus on this idea of acceptance by conduct. Now, we've been focusing on the idea of the offer for a contract. We've spent quite a lot of time delineating, for example, between an offer and an invitation to treat, talking about the communication of an offer, highlighting things like the postal rule, for example, and then also talking about what happens when a negotiation takes place, where you may have a counter offer, and the commercial context for counter offers, which exists within something known as the Battle of Forms. Now, we've then also started talking about acceptance, how acceptance is to be understood and established, and then also talking about the various different instances and processes by which acceptance takes place. This lesson is going to focus on one of those instances, talking about acceptance by way of conduct. Now, the question that we should really answer, first of all, is could conduct be a valid form of acceptance? When somebody offers you to contract, and you want to accept, do you have to make it very clear and expressly intentioned that you are accepting? Or does your conduct, your performance of the contract, in and of itself represent something of an acceptance? If you have a contract with somebody or an offer that is sent to somebody for you to perform a certain action, and then you go and perform that action, does that represent something of an acceptance of that offer and therefore validate the contract in and of itself? Well, while the general rule in contract law is that agreement can be valid if acceptance is made through express communication, and is really the gold standard if we're going to talk about trying to identify the acceptance of an agreement, it may also be inferred through the conduct or the performance of the offeree. So if you perform the obligations that you are contracting to essentially perform, if you, as a result of which, essentially perform what you are being offered to do, and that conduct is validated and is communicated, then this could infer that you have accepted the contract. Now, there are some cases that we can really think to that illustrates this point in quite a significant way. The 1877 case, for example, of Brogdon versus the Metropolitan Railway Corporation does this and highlights this idea in more detail. So the defendants in this case were the suppliers of a railway company. The railway company were the claimants. Now, they were the suppliers with coal, and they would do so without there ever being a formal contract in place. So there was sort of this general agreement between the two parties that the defendants would supply the claimants with coal. They would supply the railway company with coal. Now, despite the fact that there was no formal contract in place, a draft contract was originally sent by the claimants, but no real formalities had taken place. So there was a draft contract in the mix in and around this particular relationship. And so, as a result of which, the process went on for upwards of 2 years. And then when the defendants then decided to cease the supply of coal to the claimants tried to sue for breach of contract. Their argument was that there was a draft contract which was sent, and while there was never a formal acceptance of the contract, and there were no formal negotiations of the contract, and no real formalities in place, the fact that the defendants had performed the obligations of the contract by supplying the railway company with coal represented and infers an implied acceptance by way of conduct. And this was something which was agreed upon by the courts. There was indeed a contract, the acceptance of which was stipulated by the conduct of the defendant, and the defendant was, as a result of that, in breach of contract by ceasing to supply the coal to the railway company. So it was found that where there is a draft contract, that we have in this case here, and the parties have acted upon the terms of that draft contract, they can be bound by the contract. It is said to be representative of an acceptance by way of conduct. And so this really gives rise to a number of interesting points, specifically relating to the various different methods of acceptance that can be issued. If the offerer stipulates a specific method of acceptance, this may be enough to negate the validity of the contract if that said method isn't adhered to. So if there is a contract in place and within the contract there is a term that says that acceptance of this contract specifically has to be done through a written response, for example, or through a specific action, some kind of specific method that you do to accept the contract, and then instead of doing that method, you go about just performing the action, then it might be the case that you can negate the validity of the contract because the fact that it was not accepted in the method that was stipulated suggests that the individuals cannot be bound to it. Now, there may be an indication that the specific method is a requirement. If the offerer, for example, only wants a return by email, then this may negate the validity of a contract. And so the method of acceptance is quite important. If the method of acceptance isn't stipulated, it isn't specified, then the conduct of the parties in returning their obligations and performing their obligations under the contract may be enough to validate the contract by way of acceptance by conduct. In previous lessons, we've been talking about various different ways and methods of offering a contract, offering to contract, should I say, versus the acceptance of an offer. This lesson is going to focus on this in more detail and talk about the communication of acceptance, how acceptance has to be communicated to the offeror in order for a contract to have any kind of validity. We took a brief overview in the last lesson of the postal rule for acceptance of an offer, describing the fact that even if the acceptance of the offer hasn't officially returned to the recipient, hasn't returned to the recipient and hasn't returned to the original offerer, this does not mean that therefore negates any kind of acceptance, because the postal rule says that if you're accepting by way of post, as soon as it enters into the Royal Mail, as soon as it enters into the postal service, that is representative of an acceptance. Now, we noted in earlier lessons that this is something of an outdated method for acceptance, given that in today's context, acceptance takes a number of different forms, and most people probably don't take acceptance by way of the postal method anymore. And even if they did, the postal rule is a little bit more negated, given the fact that the Royal Mail and the postal services in the United Kingdom are far better than they were back when the postal rule was originally established. And no longer does it take 4 or 5 days for a letter to go from one part of the country to another. Today it takes about a day, depending on how much you're willing to pay for postage. So as a result of this, there are other things that we can think about in terms of communicating and making sure that your acceptance of an offer is communicated back to the offeror. As we've explained in previous lessons, unless acceptance is communicated to the offeror, there cannot be a valid contract. So if acceptance is not communicated, there cannot be a valid contract. There are general exceptions to this rule. So, for example, the use or suggesting that acceptance could be inferred through the conduct of the parties. That is an exception to this rule, because in those cases there is not an official communication of acceptance back to the offeror, but a valid contract has still been suggested to exist owing to the fact that they have performed the obligations of the contract and therefore inferring that they have accepted those obligations. Now, the principle that acceptance has to be communicated was established in the 1955 case of Entrose versus the Miles Far East Corporation. Now, in this case, we have the claimants who were in London, and they had made an offer to contract by teletext, or telex, shall I say. This is a very early electronic communication method. Of course, telex isn't used anymore, just like fax machines aren't used anymore. Some of you who are maybe in your first year of university probably don't even know what a fax machine is. And so as a result of this, this is a very an old and antiquated method of communication, but it still enshrines and underlies a very important principle within contracts. The defendants were in a different jurisdiction. They were in Amsterdam, in the Netherlands, and they had accepted the offer. Now, the issue of this case was around the question of jurisdiction, because when the claimant sued for the breach of contract in the English court, the matter of whether or not the English High Court had jurisdiction was the question for this case. Now, they would only have jurisdiction if the contract was formed in the United Kingdom, okay, and not if it was formed in Amsterdam, sorry. So what do we really have here? So if we think about this communication, you have an offer going from London all the way to Amsterdam, and then you have an acceptance of that offer going from Amsterdam back to London. So if the acceptance of the offer validates the contract at the point at which it was accepted, it would have been accepted in Amsterdam, and so as a result of which the English High Court would not have jurisdiction, because therefore the contract would have been created in Amsterdam when it was accepted. But if, as spoiler alert, it was the case in this example, it was found that the communication of the offer validates the contract, then that means that the contract wasn't formed in Amsterdam when the people in Amsterdam decided to accept it. It was formed when the original offerers had received communication of that acceptance, which means it was communicated back to London, therefore validating and creating a contract under the jurisdiction of England and Wales, therefore giving the English High Court jurisdiction. And that's what happened, essentially. The High Court did have jurisdiction owing to the fact that the formation of the contract, the point at which a contract exists, was when that acceptance is communicated. And it gets communicated when the communication is received back by telex to London, and therefore in London was it communicated. It does not create, a contract is not created when the acceptance is merely decided all the way back in Amsterdam. So, since it was held that this case was the case because the contract was formed when the acceptance was communicated. So, there you go. That is the explanation of how communication of acceptance essentially operates. Now, there are some various exceptions and various different stipulations that we can think about here. One example is whether or not silence could ever represent the acceptance of an offer. If I'm an offeror and I decide I want to make a contract with somebody and I send an offer out to them, does getting no response ever constitute acceptance? Could that ever constitute acceptance? Well, the short answer is no, owing to the fact that from the previous case, the offer has to be communicated. So if you just have a lack of response, then that can't amount to a contract. And the case from 1862 of Feldhaus and Bindley is a good example of this being illustrated. The alleged contract at issue was for the sale of a horse in this case. The claimant had offered to purchase the horse and communicated this offer by letter. As you can probably imagine, in 1862, there was no email. And so they stated in the contract that, quote, if I hear no more about him, I consider the horse, that's supposed to say horse, I'm sorry, I consider the horse mine at whatever price it was, the price that was stipulated. Now, this is quite interesting, because if that's the case, then essentially what this is suggesting here is that if you hear nothing, if you have no response from the person who is communicating the offer, then therefore it is mine. And this is almost like the inverse. So whereas, and almost like it's an assumption of contract. There is an assumption that the contract already exists, and that is only negated if you communicate back to me that there isn't an acceptance of the offer. If you don't communicate back to me, then there is an acceptance of that offer and the contract exists. It is only when you do communicate back to me. It is almost it's almost negative in terms of the way in which it is situating where acceptance lies in this particular case. The defendant in this case was an auctioneer who was told that he had to keep the horse out of sale owing to the fact that the owner was reserving the sale for the horse to a claimant. However, the defendant accidentally sold the horse when instructed otherwise. And so the claimant didn't bring a claim for breach of contract, but instead brought litigation for the tort of conversion. Now, tort of conversion is one of those torts that isn't really taught, T-A-U-G-H-T, anymore in universities, because for the most part, the vast majority of the law of tort is focusing around things like negligence, defamation, occupiers' liability, etc., etc. And so the tort of conversion is sort of pushed to the side and only really ever covered in quite niche and advanced contract law modules, or even personal property law areas. But essentially, it's an intentional tort, and we can suggest that it is the essentially with intent taking the exercising over the chattel and ownership inconsistent with the real owner's right of possession. That's the sort of general quotation that we describe in England and Wales as being the tort of conversion. You don't need to know in any great detail what the tort of conversion is and how it operates, because essentially we're talking about contracts in this lesson. It was held that there was no such claim for breach of contract if it was ever brought. It wouldn't have been, and it couldn't have been, or even the tort of conversion, owing to the fact that no contract had existed. Because there was no communication of an acceptance, there cannot have been a contract form. So all the subsequent things that happened as a result in this case was irrelevant, because there was no contract. So all of the auctioneering and the selling of the horse off to another third party was completely valid, and the individual who was trying to claim for the tort of conversion had no claim and no basis for a claim, because silence cannot represent an acceptance of a contract. In this lesson, we're going to talk about the concept of agreement and acceptance of an offer when we focus on unilateral contracts which are made. So far we've been focusing mainly on the most basic and relatively the easiest form of contractual arrangement, which is that of the bilateral contract, where you have two people or two organizations. One of them sends an offer to the other accepts that offer, you have consideration, you have an intention to create legal relations, and in certain circumstances you have formalities in place, i.e. that it is done in writing, etc., 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 and a contract is formed, and it's very simple. In this lesson, we're going to talk about unilateral agreements, where an offer is sent out to the world, it is made open, and then the acceptance of that offer is done by the conduct of an individual on return. And so one of the things that this seems to question and seems to get in the way of is this idea that the offer and the acceptance of an offer has to be communicated back to the offeror. And so we explored the postal rule, as well as the idea of silence being an invalid method of acceptance. And these were all looking at the concept of a bilateral contract. Let's see how an agreement and how the acceptance of an offer and the communication of an acceptance can be done through the use of unilateral contracts. So the rules for unilateral contracts. So we should know, and you should really intuitively understand, that the normal rules for agreement in terms of making an offer, the acceptance of an offer, the communication of the offer, the postal rule, etc., 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 they not only do not apply in unilateral contracts, but they also cannot apply because of just the nature and the formatting of how a unilateral contract works. It makes it difficult to even understand how they would apply. And let's just go straight into a case law example to give us an indication of how this works. The 1978 case of Dahlia Limited and the 4 Mill Bank Nominees Limited. This case, there was an intention on the part of the claimant to purchase a number of properties from the defendant. Now, there was an argument on the part of the claimant that an oral agreement was made on the basis that the viewing of the properties could lead to the exchanging of the contracts. And when the claimant went to the properties, there was a refusal to sign the draft contracts that were in place. And so the claimant argued that this was a breach of contract, namely the oral agreement that was made. So you have an oral agreement that is made originally, and the oral agreement says that if you come and view it, we will exchange contracts there. These properties could lead to the exchange of contracts. They come and view it, and they refuse the exchanging of contracts. And so as a result of which, the claimants are saying, well, this is a breach of our oral agreement. An oral agreement is as valid a contract as any other, so you are in breach of contract. Now, it was held that there was no contract, because they made clear that if the agreement was in writing, a unilateral contract might have arisen, okay? But it was only the fact that there was a specific formality requirement that meant that and suggested that a unilateral contract did not exist. And what this case illustrates is the fact that when you have a unilateral contract, then the offer of that unilateral contract can be offered by can be accepted, by fully performing the act itself. So we're going to look in the next lesson about acceptance by way of conduct and the ways that operates when we look at the bilateral contractual obligations. But when we talk about this in the context of unilateral contracts, the acceptance can be fully made. An acceptance can be done by fully performing the act that is being offered out in a unilateral setting. And this takes us all the way back to a very early case that we've already talked about in previous lessons, the 1893 case of Carlyle versus Carbolic Smokeball Corporation Limited. The defendants in this case sold what are known as carbolic smokeballs, and I recall an anecdote that I told when I first illustrated this case that I didn't even know, and it was many years until I found out what carbolic smokeballs even were. Even reading about this case many times and being amply familiar with it, I still hadn't ever been told, and a colleague of mine at the university I worked for told me what they were. But they essentially, the defendants in this case, who had sold these carbolic smokeballs, and they had made an advertisement in the newspaper about them. The advertisement said that if an individual uses their smokeballs 3 times a day for 2 weeks, and they were still to contract influenza, cold, or associated diseases, then this defendant, the people who sold the smokeballs, will pay them £100. It was almost a boasting of their product. Our product is so good that if you use our smokeballs in the stipulated ways that we have stated here, and we believe that you will not contract influenza, colds, and associated diseases. If you do, we will pay you £100. We'll bet you that won't happen. Okay. Mrs. Carlyle, the claimant, had then therefore used the smokeballs in the stated way and still contracted influenza, and so she wanted to get her £100 because they had failed in their bet, essentially. And it was held that, while it may seem to be an invitation to treat, there was no offer being presented here. The courts held that it was in fact a unilateral contract. Okay, they had made an offer to the world. Oopsie daisy. They had made an offer to the world. They had made an offer to anybody who wishes to take up their offer. Mrs. Carlyle accepts that offer by performing the contractual obligations in the way that the defendants had stipulated. She used the smokeballs 3 times a day for 2 days, 2 times a day for 2 weeks, and had still contracted influenza. And so as a result of which, she had accepted the contract by conduct. She had done so by performing the obligations of an acceptance. The unilateral contract requires an offer being made to the public and the acceptance being done through the specific performance, which is what Mrs. Carlyle did. And so it was considered an offer pending on performance, i.e. the use of the smokeballs. The performance represented the acceptance. And the defendant tried to argue that there was a lack of contractual intent, there was lack of intention to create legal relations. This is something that we'll get into in future lessons' time, but for the purposes of this case specifically, this was rebutted by the fact that they actually put £100 in a bank deposit and showed that this deposit existed. So not only did they say, we'll just give you £100, but they had actually earmarked out that £100 and put it in a bank deposit ready for anybody to try and claim it, making it very clear that they had intention to uphold their own obligations.